I'm Dale Harmon, and the day I bought that farm, nobody mentioned that 47 suburban families were drinking from a well on my side of the fence. They'd been doing it for 11 years, quiet as thieves and entitled as royalty. They never asked, never paid, never recorded a thing. And by the time they realized I wasn't the kind of man who ignored details, it was already too late. I spent 23 years as a civil engineer, mostly land grading, drainage, and water infrastructure. I knew how water moved, how rights got assigned, and how fast a temporary arrangement could turn into permanent theft if nobody stopped it. When I retired at 54, I wanted land, not an HOA. I found it in a rural county, just over 1,000 acres of pasture, timber, springs, creek bed, and tillable soil. I paid cash, took possession in April, and for a few weeks I got exactly what I wanted: sunrise walks, coffee, and a thermos silence. My surveyor found the pipe on the third day. His name was Gerald, the kind of careful man who treated every boundary marker like it mattered. He called me to the western edge of the property where my farmland touched Maplewood Estates. There was a shallow wellhead on my side of the line. Buried black pipe ran from it underground and crossed straight into the neighborhood. Gerald flagged it, photographed it, logged the coordinates, and added it to the survey. I stood there looking at it and didn't feel anger. I felt focus. The wellhead was mine. The land was mine. If they had the legal right to that water, there would be paperwork. That night I pulled every county record again. No utility easement, no water rights transfer, no shared use agreement, nothing. When Gerald's certified survey came back, it confirmed exactly that. I copied the whole thing, labeled a binder, and sent one set to my attorney, Patricia Cole. Patricia called that evening. She said one word first: trespass, then the better word: patience. So I watched. I photographed the wellhead myself, time-stamped. Everything got the boundary marker in frame. A few days later, 2 contractors in an unmarked truck opened a valve box just inside the HOA side, checked something, and drove off. I logged it all. Then the first letter arrived from Maplewood Estates, signed by the board president, Richard Thorne. It was friendly on the surface, which almost made it worse. He said the community had historically relied on a shared water source near the boundary. Shared. No legal document attached, no citation, no explanation, just a smooth assumption that I'd continue letting them draw water from my property because that was how things had always been. I scanned the letter and sent it to Patricia. She replied fast: "Save everything. Do not respond." At the county office, I pulled deed history, plat maps, groundwater permits, anything tied to my land and the subdivision next door. That was where the first real twist showed up. The well had been drilled 18 years earlier by the previous owner of my land, Elton Marsh. The subdivision came later, the HOA came later, and nowhere in any filing was there a recorded easement giving Maplewood Estates the right to that well. I tracked down Elton Marsh's daughter, Carol. She still lived nearby, and when I asked about the well, she knew exactly what I meant. Carol told me the developer had approached her father years earlier asking to tap it temporarily during construction. Elton said no. They came back and asked again. He said no again. According to Carol, they connected to it anyway, and by the time he realized the pipe was still feeding the neighborhood, he was too sick to fight. Patricia took Carol's statement formally and added it to the binder. By then I had a survey, photographs, county records, and a witness statement saying the previous owner had refused permission twice. I still didn't touch the pipe. I let the facts do the work. Richard Thorne, meanwhile, got bolder. His second letter dropped the polite act. He warned that any interference with what he called community infrastructure would be treated as a hostile act. Patricia loved that letter. She said it proved Thorne was claiming my well as HOA infrastructure without a lawful basis. Then we hired a hydrologist named Marcus Webb. He installed a temporary flow meter on my property and measured usage for 72 hours. Maplewood Estates was pulling roughly 18,000 gallons a day. Every day. Over 11 years, even at conservative county rates that came out to real money. Then one Saturday morning, a homeowner named Gary Purcell knocked on my door. He was on the HOA board, but unlike Thorne, he looked uneasy. He asked if there was any path to some kind of legal arrangement, an easement compensation, anything that might keep the neighborhood from imploding over this. I told him maybe, but only in writing, only through attorneys, and only after the facts were complete. He left looking more relieved than when he arrived. Patricia said that told us what we needed to know. When the other side starts sending private envoys, they're scared. A few weeks later, she forced the HOA to produce internal records. Buried in those records was the document that cracked the whole thing open, board minutes from 11 years earlier, showing a formal motion to pursue a legal easement from Elton Marsh. The motion passed 4-1. In a later meeting, the follow-up read, "Easement pursuit tabled indefinitely." They had known from the beginning they needed permission. They had voted to get it. Then they'd chosen not to and just kept taking the water. By then, an appraiser had valued the water they'd taken, and a second water rights attorney had confirmed our legal position was strong. So Patricia sent the formal legal notice. 3 choices: negotiate a paid easement with compensation for the past stop using the well and remove the pipe at their expense, or get sued. Richard Thorne answered the way prideful men usually do when the bluff stops working, with anger. He left me an aggressive voicemail saying I was threatening the water security of 47 families. Then the HOA's attorney came in, swinging with talk of implied easement and long-term reliance. Patricia answered every point and kept the deadline in place. The closer we got to that deadline, the more the HOA started splitting at the seams. Gary called again and said the community didn't have the money for a long legal war. Then Thorne made the mistake men like him always make. He went public too soon. He sent me one last letter saying a decent person would simply grant the easement without compensation. We met in Patricia's office a week later. She laid out the evidence piece by piece on the conference table: county confirmation that no easement existed, the hydrology report, the appraisal, the board minutes, Carol's statement. Thorne watched the stack grow and looked less certain with every page. Their first offer was insulting. Patricia didn't haggle. 4 days later, she filed suit. A local journalist pulled the complaint from county court filings and wrote an article. Then another. Suddenly, Maplewood Estates homeowners were learning that their neighborhood water source came from a well they had no legal right to use. At the HOA annual meeting, one homeowner stood up and read the old board minutes out loud, the part about the easement motion being tabled. Gary later told me the room got loud in a hurry. By the time court arrived, their confidence had thinned out. Judge Claire Sutton ran a tight courtroom. Patricia was precise. Gerald testified to the boundary. Marcus testified to the water flow. The appraiser testified to value. Carol testified that her father had said no twice and been ignored anyway. Then Patricia introduced the HOA minutes and read the key line into the record. The motion to pursue an easement had passed, then been tabled indefinitely. You could feel their good faith defense die right there. Richard Thorne testified for the defense and tried to wrap the whole thing in community reliance and fairness. Judge Sutton interrupted him twice, once to ask why the board had tabled the easement, and once to ask why homeowners had not been told about the legal risk. His answers wandered. 30 days later, the ruling arrived. We won on every count: trespass, unauthorized extraction of a natural resource, unjust enrichment. The implied easement defense was rejected outright. Damages came in at 92% of our appraised figure. Attorney fees were awarded in full. The HOA was ordered to stop drawing water from my well within 45 days and remove the pipe from my property within 90. And then came the part that felt less like law and more like karma finally waking up. The newspaper ran the ruling. Richard Thorne resigned 4 days later. Other board members followed him out. A new interim board got elected, led by one of the homeowners who had challenged him. That man called me personally and said the new board would honor the ruling, remove the infrastructure, and find a lawful water source like they should have done years earlier. The contractor came out on a Tuesday. Gerald returned to verify the line was clean. By the end of the day, the buried tubing was gone, the boundary was clear, and the well on my land stood capped and quiet. The damages payment landed before the next month ended. What stayed with me wasn't really about water. It was how easily people start calling something normal just because they've gotten away with it for a long time. If enough years pass, theft puts on nicer clothes. It starts using words like tradition, reliance, community need. It starts sounding reasonable. But sounding reasonable and being lawful are not the same thing. Richard Thorne thought silence meant surrender. He thought 11 years of uncontested use would magically turn somebody else's property into a neighborhood asset. What he never accounted for was a new owner who surveyed early, documented everything, hired the right people, and let the law move at its own patient pace. The law doesn't always move fast, but it has very little respect for arrogance once the paperwork catches up. I still walk that western boundary most mornings. Same stretch of ground where that hidden pipe used to run. Only now the line is clean, honest, respected, And I won't lie, there's something deeply satisfying about standing on your own land knowing the people who treated it like free inventory had to dig every inch of that pipe back out with their own money. So here's the question. When an entire neighborhood depends on something it was never legally entitled to, does defending your rights make you fair or make you the villain? Tell me where you land and if you've ever dealt with an HOA, a power-hungry board, or a neighbor who thought they could take first and explain later. Share your story too. I want to hear what justice looked like on your side of the fence.